morning. I'll introduce myself, Ken Slater. I think most of the folks, if not all the folks, I've seen names pop up I know well, or at least have met. The other presenters this morning will be Rich Roberts to my left. It might surprise you. We're always looking forward to lawyer jokes. The last thing you might expect is that the governor would consider the legal profession essential. So we're not violating any rules by being a couple of the few people who are coming in here. Our office, like a lot of offices, are mostly shut down. Rich and I have virtually been quarantined together, so we don't have to follow the 6-foot rule together. The other folks that are on the line that are going to present this morning, Duncan Forsyth and Jen Petafilano, we're going to talk about employment and labor issues that we're addressing right now. Mike Zitzka is online. He's going to talk about some of the implications of the executive orders related to land use, and perhaps in land use hearings, maybe in particular. I'm going to touch on the virtual meetings and technology. And what I was saying, for those who were able to lip read before, we haven't used this software for such a large group before. So far, our tests, it's been pretty effective, but bear with us if we have some technology issues. We are recording it, and if it works, we'll have a link to this to our webpage. A lot of you should have been receiving our updates regarding the executive order. Rich has especially been on the forefront of working on a whole host of the executive orders with liaisons to the governor and CCM and cost. Mike, Mark, and Rich were involved in the one dealing with the land use. So we've all been trying to keep a pretty close eye on everything that's happening to try to advise you all. But we thought it was important, when you engage us, we want to let you know that you're special to us, and we try to give you some special services and training. And we thought this would be an opportunity to have our client-only session. And if you did happen to invite somebody who's participating who's not involved with a client, don't worry about it, because my lawyer caveat here is, because we have a whole host of people who are different clients, what we're talking about today really won't be protected by the attorney-client privilege, and it would be something that would be disclosable. If you ask a specific question, because we do want to give you an opportunity to ask specific questions about some of the specific issues you're dealing with, if we discern it's something that we really need to deal with offline, we'll tell you, and then we'll connect offline and we can deal with it where you really will have the attorney-client privilege associated with the conversation. But you really should feel free to lay out whatever your problem is when we go to the Q&A later on. I'd like to ask Duncan to briefly comment on some of the things we're trying to do on our website to provide a resource to you, both generally as we try to keep you up to speed on municipal issues, but also in particular what we're doing right now with all the COVID-19 stuff.
Good. Thanks, Ken. Good morning, everybody. First of all, if you do us a favor, at the bottom of your screen, you will see the mute microphone icon. So if you all could click that, I think it'll help everybody so that we don't have a lot of background noise from a bunch of people. One of the things that we have done over the last 2 weeks is prepared a number of client alerts to help you try to navigate some of the issues that you're facing on a daily basis. And so if you were to go to the Halloran Sage website and go to the home page, right in the middle of the homepage screen, you'll see this big red banner that says, visit our Coronavirus Resource Center. And if you click that link, you'll see a number of boxes. Foremost is the client alerts. And since mid-March, we have issued 17 different client alerts on a variety of topics, both public sector and private sector. And while I know most of you are full-time municipal officials, some of you may in fact have other day jobs, and you certainly have friends, family members, and constituents in the public sector. and you may find some of these relevant and helpful to them as well. Additionally, in the Resource Center, we have every single executive order that has been issued by the governor since March 12th, which I think now total 22. So it's a very easy reference center if you need to access any of those in particular to understand exactly what they say. So please take advantage of it when you have some time, just to kind of peruse it. And I'm certain that you'll find some stuff that's very valuable to you, to your colleagues, and to your constituents. So thanks.
Thanks, Duncan. I'll echo what Duncan said before, and I was doing it earlier with my lip read. Again, encourage some folks might have come on just moments ago, and we can hear some shuffling and such. So if you could mute, you'll see the button at the bottom of this life-size software to mute it, and then later on during question and answers, if you have any, you can unmute to ask the question. And with that, again, I'll say again, Rich has been working all hours and is really at the forefront of a lot of these executive orders. There's portions of them that are probably incomprehensible are the parts that Rich wrote, but he at least understands what they all mean. So with that, some of the things are on our invitation, but there's also been executive orders that have come up. So I expect Rich might take a little longer than the rest of us because of the update on some of the recent orders in addition to the ones that have already been the subject of some of our alerts.
Thanks very much. And I guess, you know, for those of you who have been watching Ozark and Tiger King instead of obsessively reading the governor's executive orders at home every night, what I thought I would do, given the constraints of time, was just kind of briefly identify and summarize the ones that pertain to municipal budget, municipal finance, and tax issues. And you know, I know I've spoken to several of you already about the logistics and the interplay and how they work as opposed to what they mean, and what they mean as opposed to what they say. But they're basically, at this point, I think 3 of them that are relevant to municipal budget and finance issues. First one is 7C that came out, it seems like 8 months ago, but it was probably 2 weeks ago at this point, which essentially set up a mechanism by which the budget deadlines that might be established in your charter, in ordinances, policies, and procedures, or just your own informal calendar in how the budget process works in your town, can be pushed off by up to 30 days, at least with respect to all of the items that were supposed to occur on or before May 15th. And the concept behind that one was essentially to give town some breathing room, because at the time it was issued, I mean, literally there were budget hearings scheduled for the following day or the following week. And you know, at that point, nobody had really come to grips with social distancing and virtual meetings and all that sort of thing. So it was basically, what was in 7C was designed to push off the deadlines so that, you know, notwithstanding the fact that your charter calls for a budget hearing on April 1st, you can have it, you know, up until May 1st. The second one that is relevant to the budget and finance issues was 7I. And what that one does in general is take the process, you know, which may or may not have been extended by the legislative body or the Board of Selectmen under 7C, and says, basically, you follow your process, you know, as it may be extended. You follow your process to the best of your ability in accordance with the virtual meeting requirements set forth in 7B. But basically 7I says that if the last stop in your budget adoption process is either a town meeting or a referendum, that you are not supposed to hold those things during the pendency of the pandemic or the the declaration of emergency, and that the legislative body, or if you're in a town where the legislative body is the town meeting, the Board of Selectmen can basically authorize / direct budget-making
Look how good he
authority,
is. I was just giving him a hug. Look.
Board of Finance, if you're in that situation,
So good.
to adopt the budget and set the mill
I was
rate
just hugging you.
so that you can move ahead without
He's not asking
having
you
to hold a town meeting or a referendum when the social distancing and the prohibition on large gatherings is in effect. One of the other things that
I'm going for coffee.
that needs to be kept in mind with that is that you want to have that interact with the time extension opportunities that you've been given. So kind of one of the things that I think some towns are doing is basically extending the process, everything except the very last step, which would be to authorize the Board of Finance to go ahead and adopt the budget, so that, you know, at least theoretically, they can take stock of what the state of the world looks like on May 15th or June 1st and make an educated guess as to whether in the near future, is it realistic that we're going to be able to have, you know, an in-person town meeting or a referendum or not, and to respond accordingly. So if you're in the situation where it looks like the restrictions are going to be in place until July 1st, you need to adopt a budget, you need to get your tax bills out. You know, at that point, you'll be able to say, look, let's just move the freight here. And Board of Finance, please set the budget and set the mill rate and go on. The other thing that came out the night before last is Executive Order 7S, and there are two kind of finance and tax components to that one. The first one I'll just go over really quickly. It gives towns the opportunity to deal with non-budgetary appropriation things, tax anticipation notes, and bonding that may otherwise require a town meeting or a referendum. It gives the opportunity to move ahead with those if you get the concurrent majority vote of both the legislative body or the Board of Selectmen if it's a town meeting, and the budget making authority saying, you know, it's important that we make these budget transfers. We need to get the tax anticipation notes issued. You can do those things without the town meeting or the referendum as long as you make certain findings regarding the urgency of doing those things, or that it's necessary to do those things now in order to avoid, you know, destruction of property or loss of, you know, significant loss of revenue or value to the town. So if your town hall roof is leaking and you don't want to wait until July or August to figure out if you can have the town meeting, you know, to either make a special appropriation or issue the bonds to finance those kinds of things. Section 7 of Executive Order 7S gives you the opportunity to do those as long as both the Board of Selectmen and the Budget Making Authority make the relevant findings. The other thing that is significant in 7S, and this is kind of a moving target, is that it essentially requires towns to provide one or both of some options available to taxpayers. The first option is essentially up to a 90-day deferral of any tax, charge, assessment, or levy that becomes due anywhere between March 10th and July 1st. Note that does include the July 1st tax bill. So, you know, it's already in place for towns that have quarterly tax bills. It is in place for water and sewer charges that are being issued prior to July 1st, and it will be in effect, you know, unless it's revoked sooner for the July 1st tax bills. So the option for a deferral is on the table. The important thing to keep in mind for the deferral is that people have to apply for it and be qualified for it. OPM is putting together guidance as to what the requirements are to be qualified, you know, and it's essentially that you've had a substantial loss of income as a result of the virus or situations associated with the virus. The second program that's out there is basically called the low interest program. What that does is it, instead of the normal 18% penalty interest on delinquent payments, it reduces it to 3% for a 90-day period during the pendency of the pandemic. So if you go with the low interest one, basically people who have forgotten to pay their taxes from last July, you know,
Rich, you're muted.
only at 3% instead of the 18. As I said, you know, the governor's office has made the policy decision that towns must offer one or the other or both of these to their taxpayers and residents. You have until the end of the month basically decide which of them works for you, which of them or both, you know, you think is appropriate as an accommodation to your taxpayers and residents. I'm not going to belabor it, but there are some special provisions that apply to landlords. You know, frankly, I think they were ill-conceived and are relatively undefined at this point, but there is further guidance that's anticipated to come out from OPM and the governor's office on how that works. Now that I've lulled you all to sleep with my yelling about executive orders on budget and finance, who's next?
Me. Turn it over to Ken. I'd really remind everybody again, I don't have the ability on my end, at least from using this equipment in here, to mute everybody else. You saw I accidentally muted us while I was trying. So just another reminder, please, to whether you're on by telephone or you're on by video, if you could mute your phone or your screen, we are all getting a little bit of background, if not a lot of background at certain points of time. So I will just jump off from one point about what Rich said that hasn't happened yet in an executive order, and that is town meetings that don't specifically don't fall within the framework of the financial issues, either the general budgeting or the more recent executive order dealing with appropriations, et cetera. There are some towns we represent that have a timely need to have a town meeting to adopt an ordinance and take some other actions that aren't directly financial that they need to do in the short run and not the long run. You probably all heard about the creative effort that the town of Vernon did to try to do drive-by voting at a town meeting. You know, frankly, we don't think that qualifies as a town meeting on how that is meant in the historical, you know, government of the state of Connecticut. It was creative. Maybe it'll work, you know, likely not challenged, which is a certain reality in all of this too. But right now, there is no executive order that would give you the ability to have a town meeting that would do something not related to the financial. So we're keeping an eye on that. We think that might be addressed, but they're trying to take care of one thing at a time when they're going through these executive orders, and they're taking care of the things that are most important. So when you do a virtual meeting, and by the way, we'll point out that if you do opt to, and the whole purposes of these executive orders, and what we're all trying to accomplish is to avoid people getting together. The governor's executive order does not prevent a meeting that involves more than 5 people if it's related to a governmental function. We're all trying to avoid that, but it doesn't. So that if push comes to shove and you made a judgment call that you'd make every effort to make a meeting virtual, but you are going to need to provide some kind of an opportunity for people to attend. And Mike's going to touch on that a little bit when we're talking about it in the land use context. There's no prohibition against you doing that, but obviously we're trying to avoid that altogether. Now, when you do the virtual meetings, the ones that we know you can do under executive order, 7B, which exempts certain requirements under FOI, certain requirements of your charter or ordinances to have an in-person meeting, you can use technology to do so. And there's a number of different kinds of software to do it. Go to Meeting, Zoom. Zoom seems to be a popular one, although be wary. You've also probably heard there's been some hacking and some ability to hack into Zoom. Some of the other products out there, I know there's been efforts to try to avoid the ability to hack. I think GoToMeeting, I think Google's software, they've been working on doing that. So that's something to be mindful of. But you need to comply with certain requirements in order to do that. When persons participate, they have to have the ability to view or listen to the meeting in real time. Just making a recording and having it available later does not comply with the executive order. It needs to be recorded, so that's something to pay attention in terms of the technology out there. Some of them, this one, for example, I mentioned maybe when the audio was off, we are recording it. We do plan to have this available on our website if you've missed things because of maybe, for whatever reason, had to join late or will leave early. You have to have that posted on the website after it's recorded and within 7 days of the meeting, and then made available within a reasonable time after the town offices open back up again. The required notice of the meeting and agenda can be posted on the website as opposed to the traditional methods. And one idea that was mentioned yesterday when we prepped for this call was you might want to think about putting a general notice on your web page just to notify everyone that meeting notices are going to be posted on your web page so that people will continue to pay attention for particular meeting notices and just have a general notification out there. You also have any materials that are related to the agenda or anything that's submitted relating any applications have to be submitted and posted on the website so people have the ability to look at what information is available there. And then all speakers taking part in the meeting have to clearly state their name and title before speaking. And, like any other instance where you run a town meeting, sometimes it's easier said than done, but make every effort if you're allowing, in the kind of meetings we're talking about, there's probably not going to be public input. It's just going to be an agency meeting or a select meeting, et cetera. You don't need to be having public input, so it'll just be amongst yourselves, but you need to, even if you're not accustomed to doing that at a Board of Selectmen meeting, for example, because it's a small meeting and normally everybody in the room knows who everybody else is, you need to state your name each time you speak so that a person who's listening on either at the time of the meeting and in real time or later on is going to know who is speaking. So if you comply with those specifics of Order 7B, that complies with the virtual meeting requirements of at least a regular meeting. And again, keep an eye out for executive orders on public town meetings or that need to be taken place that wouldn't fall under this because those specific requirements wouldn't meet all of those requirements. One thing we've also done, recommended towns to try to do, and we know a couple have done, in this case it was land use context, but I'll defer most of the land use discussion to Mike in a moment, if you could, with your general meeting notice or your specific meeting notices, ask people to contact staff in the event that they don't have the ability to participate electronically. It's not necessary for just an agency meeting. But if it's a public hearing, or if we get to a point where you have to try to do a town meeting virtually, then if nobody asks for special accommodations, then you don't have to worry about it because they would have lost the right to be able to challenge it later on, having not asked. And then the same thing. If they do ask, however, you do have to make some kind of an accommodation, and that could include. I thought I'd put my phone, it is on Do Not Disturb, but it's ringing anyway. You would have to make some kind of accommodation, putting a monitor out on even outside a building if you wanted to, so that people could hear what's going on. And you could place, kind of like what's happening when they're doing the press conferences with the president. You have seats 6 feet apart. You could do those kinds of things if you opted to. to try to accommodate the fact that right now, town meetings are not accommodated in all of the orders. So with that, I'll turn the floor over to Mike Zitzka to talk about the executive order as it relates to land use deadlines and that land use process, as well as an overlap probably with some of the stuff I've just mentioned.
Okay, thank you, Ken. The provisions of the land use section, or most of the land use provisions, are in Order 7I. Are you hearing me first, Ken?
Yes.
Okay, good. All right. Just wanted to make sure. The first one is any time deadlines that were set for either the beginning of or for the time to commence a hearing from the time that an application is deemed to be filed, the completion of the hearing, or the time to make a decision after the hearing, all of those normal requirements have been suspended or at least continued by up to 90 days. What that means is, if you have a situation where an application has been filed and you would normally have 90 days from the official date of receipt to render the decision, you now have 180 days to do that. If it was one of the types of applications that gives you 65 days to commence the hearing, 35 days to complete the hearing, and then 65 days after the hearing to make a decision, the total time frame is extended by 90 days. Now, as most of you working in the land use area know, the statutes providing for those time frames include their own extension provisions. However, those extension provisions are subject to consent of the applicant. But if the applicant is willing to consent, those additional extensions do not count in the time in the 90-day time frame that this executive order is covering. So what that means is, if you have a situation where it would be 65 days to commence a public hearing and the applicant agrees to allow you to extend that time frame by up to another 65 days, that doesn't count for the extra 90 days. So in theory, you could have the 65-day initial period, the 65-day extension from the applicant, and then the 90-day period from Order 7I to commence the public hearing. But as is true with the time extensions that the applicant consent to, this 90-day period, one period. You can allot it among the various components, but you can't use 90 days to begin the hearing, another 90 days to complete the hearing, and another 90 days to conclude the hearing. It's one 90-day additional chunk that you get. So just to give you an example of that, a quick example. Let's say you have one of those situations and the applicant says, all right, I'm going to give you 20 days extension to open the public hearing, so you have 85 days, but the commission finds, well, that's not really enough. Then the commission can allot as much as it wants to of the additional 90 days to that period to begin the hearing. So if the agency were to allot another 20 days, it would have 70 days left from the 90-day period. And there would also be 45 days left from the statutory extension period that the applicant can consent to. I know that may all sound a little complicated, but just think of it this way. The order gives you an additional 90 days to allot from the beginning to the end of the process. If the statutes give the applicant another 65 days that the applicant can consent to, and the applicant does use any of that time, it doesn't count for the 90 days. I would suggest, probably, while commissions are still trying to figure out how best to hold these meetings electronically, or maybe even wanting to stall the beginning of the meetings with the hope that maybe enough of the enough of the emergency will go away that you can start holding physical meetings again. You may want to allot more of the time just to the commencement of the meeting so that you have more time to figure out how you want to go through this process. As you can see from our electronic meeting today, not all of the bugs are worked out. So in terms of having a meeting of a commission where applicants and opponents and other interested parties should all have the opportunity to speak and should all have the opportunity to hear and respond to one another and should all have the opportunity to see whatever documents have been submitted. That's going to be much, much more tricky than just what we're doing here today. But so again, my suggestion would be you probably want to allot, if you have to, the 90 days as much as possible to the upfront proceedings, figuring that by the time you get the process started, you'll have most of those bugs worked out as best you can, and you won't need as much of the 90 days on the tail end. But that's how it works. It's 90 days to be allotted from beginning to end of the process. You can allot it among the various time frames. It's not up to the applicant. The applicant can't control this, although the applicant under the order can actually require you to provide them additional time. It does actually say that the applicant can ask for a portion of that 90 days to be allotted to the time frame, and under the literal language of the order, it sounds like the applicant can actually demand that, although I don't think many applicants will. Usually the applicants are trying to get through the process as quickly as possible. The second is if any of you are involved with the demolition delays, usually these are historic district commissions that are concerned about historic properties, and you have a demolition delay that's going to be involved in the process, then this executive order adds another 90 days to that demolition delay. It's a very special statute, 7-147J, but if you are involved in that, there's an additional 90 days. Now, the notice requirement is the second big part of this executive order. If you're required to publish a notice in a newspaper of general or substantial circulation, the order suspends your obligation to do that and allows you to do it electronically on the municipalities or the agency's website. Some towns have separate websites for their land use agencies, so it can be done either on the municipalities or agency's website, provided the deadline for posting, the earliest deadline that would be required, is the one that is complied with. So, for instance, in most of the land use situations, the first published notice would ordinarily be published 10 to 15 days prior to the start of the meeting. That's the time frame you've got to comply with. If you comply with that, you don't have to do a second notice. Wouldn't make any sense because the notice is already on the municipality's website. And the other requirement is it has to remain there until the completion of the action, meeting, or proceeding for which the notice was published. So the notice goes up in the normal time frame for publishing the very first notice that's required, and it stays there through the end of the process. We would also recommend that it stays there through the appeal period. So after a decision is published, and again, that can be done electronically as well, you would leave that first notice up until the end of, at least the end of the appeal process, which would be 15 days after publication of the notice of decision, which again can be on the website.
Mike,
Sorry, go ahead.
Mike, just two brief thoughts. This is Mark. One would be, once you put that notice on your website and you've complied with the minimum 10 to 15 days, my suggestion would be to print it and somehow date it so that after it's deleted, you can prove that it was up there. One of the problems with electronic documents is once they're deleted, it's very difficult to prove that they did exist at the time you say they did. So a hard copy with some sort of notary or something saying that record, a date stamp, something that shows that it was really there. The other thing that we've talked about with a number of our clients is while you still have newspaper coverage, if you have it in your town, some towns have already lost their local papers. Glastonbury has, but you do some sort of legal notice just saying, from now on, check the website. Don't look here anymore. Look at the website if that's how you're going to do it.
Okay, good points. And I would also say one of the things that nobody knows at this point is what's going to happen when some of these things go up under appeal. We're sure that one of the things that's going to come out of this situation is there are going to be a lot of appeals that are brought claiming that either the executive orders were illegal or that there was something about them that violated due process or something like that. We can't anticipate how many of those types of appeals there are going to be. So the advice that Mark is giving is good advice, because what we're trying to do is risk management here. We're trying to protect our municipalities as much as possible. So as much as you can do to backstop your electronic postings, the better. One other suggestion, Mark, I could add to that as well. If those of you that know how to take a web shot, a screenshot, usually when you take the screenshot, down in the bottom right-hand corner, it will show the date. So if you at least take a screenshot, that will be something else that you can have to show the date that the electronic notice will come. All right. The next notice the next notice requirement is those statutes that require notice to be filed in the office of the town clerk, the municipal clerk. Those are suspended until the completion of the action. Those again can be substituted by the posting on the agency's or the town's website. This one actually specifically says on the municipality's website. So if there are two websites, if there's a land use website and a town website, a notice that has to be filed with the municipal clerk, make sure that gets to the town website if it's different from the agency website. So you might consider having one in both areas, under the town clerk's notices and under the agency's own notices on the website. Any law requiring a physical sign to be posted is suspended, and that can be satisfied by the electronic posting, again, on the municipality's website, not just on the agency's website if there is a separate one. The next one is trickier, and that's any covered law requiring notice by personal mail to a specific recipient. That is also suspended and allowed to be published by electronic mail notification, as long as the electronic mail addresses of the intended recipients are reasonably known to whoever has to provide the notice, whether it be the municipality or the applicant. But if the person or agency that is required to provide the personal notice by mail does not have an electronic mail address for the recipients, and of course many private individuals, the individuals who own property within 100 feet or whatever, you may not know their electronic mail addresses. So for those, you can satisfy the requirement either by posting a physical weatherproof sign at least 2 feet by 3 feet in a prominent location on the parcel of land which is the subject of the application. So you can satisfy it that way. It's kind of ironic. The requirement that you post a sign can be substituted by electronic notice on the municipality's website, but the requirement to provide personal notice by mail can be satisfied by the posting of the physical sign. And again, that's to try to do as much as possible for those people who do not have the ability to electronically connect or electronically receive notices, or whom you just don't know the addresses of. So you can satisfy it by that type of a sign, or simply by mailing the letters. Nothing in these rules stops you from going through the normal process. At least nothing in these rules do. There may be some about gatherings and so forth that would stop you from having a physical meeting, but nothing stops you from actually physically mailing to the intended recipients. That can still be met that way. The electronic notice was simply an alternative opportunity to the extent that you know the email addresses. There are some types of applications for which, or some types of processes for which petitions can be submitted, and it requires people to gather the names of people and to personally be there when the petition is signed and so forth, to verify that this is a true signature. Those types of petitions are covered by another section of this electronic or this order regarding electronics, and those petition procedures are suspended to allow the petitions to be signed electronically. Now that can be done by any type of imaging technology that works, or by a compilation of emails. If you get emails from a variety of people saying they want to sign the petition, you can compile those emails and that will be sufficient, or any other way of gathering the signatures or the consents electronically will work. Any law prescribing the procedure for commencing an appeal of a decision to the Superior Court. I'm not going to cover that too much. It can be done by a proper officer by electronic mail notice. You're not going to personally have to worry about that so much. That will be more for the state marshals or whoever the process servers are to worry about. But you have certain situations where an appeal can be filed from an inland wetland enforcement officer's decision to the agency, or from a zoning enforcement officer to the CBA. And in those cases, those procedures can be now accomplished by electronic mail under this governor's order. The time to commence the appeals is remaining unchanged under those provisions. The final section of this order, which is a catch-all and is very important, is that those electronic notifications have a proviso, and that is the municipality within a reasonable time after the reopening of the relevant office has to include the printed versions of all modifications, extensions, notices, and decisions in the permanent town records or permanent municipal records. Any document required to be recorded or filed in the town or municipal clerk's office has to be recorded or filed as soon as possible within a reasonable time after the office reopens. And any municipality may, by declaration of head of an agency accepting or administering applications, waive any rules, regulations, or policies related to any requirement that applications to such municipal agency be submitted in paper copy or duplicate. That gives the chairperson of an agency the opportunity to say, yeah, we normally require 7 rolls of site plans to be filed with our office so that all of the members of the commission can have one. That allows the agency head to say, we're not going to require it. We're going to allow that to be done electronically. And it's an interesting point because the agency's head doesn't have to do that, but certainly it would be appropriate. If the agency doesn't do that, then they're going to have to figure out some way to have all of these documents available for the people to see during whatever electronic meeting they have. As I think Ken pointed out before, if you're going to have an electronic meeting under Executive Order 7B, you still have to make all of the documents that are pertinent to that meeting somehow available for people to see on the website. So it's to your advantage. If you have a requirement that 7 paper copies of site plans be filed, it's to your advantage to say, we're going to waive that, we're going to allow electronic filing. That way the agency has the electronic file to post on its own website. I don't want to take too much time. I know I've spent a lot of time already, so I'm going to turn it back over to Ken at this point.
Thanks, Mike. At this point, I'll turn it over to Duncan Forsythe and Jen Petavillano to touch on some of the labor employment issues that are implicated by the crisis and these orders.
Yeah. Jen, why don't you go first?
Yep. So I'm going to start just briefly going over 2 things that Congress have released recently under the Families First Coronavirus Response Act, and that is the emergency paid sick leave and the expanded FMLA that I'm sure you have all heard about. The DOL recently released their rule on it, which has answered some of the questions that initially existed, but also created a lot more questions, which is to be expected. So I'm just going to do a general overview of it. There are a lot of nuances to the calculations of different things, and if anyone has any specific questions on that for specific employees, we're happy to address that with you off of this conference. So the first question is, do these new laws apply to me? And the answer is yes. They apply to public agencies that employ 1 or more employees. It includes states, public subdivisions of the state. The Emergency Paid Sick Leave Act provides for 80 hours of paid sick leave for a full-time employee. For a part-time employee, the amount of paid sick leave available under that act is based on the number of hours the employee works in an average 2-week period. And there are instructions on how that gets calculated and how it's calculated if the employee's schedule varies week to week. There are 6 reasons you can take the paid sick leave. One is if the employee is subject to a federal, state, or local quarantine or isolation order. These are all due to COVID-19. The second reason is if the employee has been advised by a healthcare provider to self-quarantine due to COVID-19. The third reason being if the employee is experiencing symptoms of COVID-19 and seeking a diagnosis. If an employee is seeking paid sick leave for one of these three reasons, that employee's paid leave is capped at $511 per day, or $5,110 in the aggregate. If the employee's regular rate of pay would be less than the $511 per day, then you use the employee's regular rate of pay. The next three reasons for taking the paid sick leave have a different rate of pay associated with them, and that's why I've separated them out. So the fourth reason is if the employee is caring for an individual who is subject to a quarantine or isolation order. That can include a child, a parent, a grandparent, a spouse, a roommate even, according to DOL. The fifth reason is if the employee needs to care for a son or daughter who used to be in childcare, whether it was a daycare, a school, or with an individual provider, and that school or daycare or childcare provider is no longer available due to COVID-19. And the sixth reason is a catch-all, any other substantially similar conditions specified by the U.S. Department of Health and Human Services. For reasons 4 to 6, the daily rate of pay is capped at $200 per day, or $2,000 in the aggregate. Again, if the employee would normally be paid less than $200 per day, you would look at the employee's regular rate of pay. Now, under this, you can exclude an employee from the paid sick leave if they are a healthcare provider or an emergency responder. And those definitions, according to the DOL, are quite broad in these circumstances. So, not to go over the entire definition, but a healthcare provider is not only a doctor or a nurse, it is also a local health department or agency. It includes nursing or retirement facilities. It also includes any employee or entity that contracts with any of those institutions to provide services to maintain the operation of the facility. And it allows the governor to designate others that he would consider to be healthcare providers under this act. The emergency responders under this act includes anyone necessary for transport, care, healthcare, comfort and nutrition of patients or others needed for COVID-19. It includes law enforcement officers, correctional institution, firefighters, EMTs, paramedics, public health personnel, emergency management personnel, 911 operators, service providers, public works personnel, or any other individuals working for those facilities that employ the emergency responders whose work is necessary to maintain the operation of the facility. That, in theory, could include someone on the administrative side as well. And again, the governor can denote others that fall within this definition. If you chose to offer any paid sick leave prior to April 1st, which is the date this act took effect, that prior paid sick leave you offered cannot be used to meet the requirements of this act. So this is new paid sick leave that's available April 1st and forward through the end of the year. To qualify for the paid sick leave, there's no requirement that the employee worked for the employer for a specific number of dates. The second provision that recently came out in the Families First Coronavirus Response Act is the expanded FMLA. Again, this would apply to you as municipalities. The expanded FMLA is only available if the employee is unable to work or telework because they need to care for a son or daughter whose place of care or provider is unavailable due to COVID-19. So it's only reason 5 under the paid sick leave. Unlike the emergency paid sick leave, which does not have a requirement for length of employment, to be eligible for the expanded FMLA, the employee must have been employed for 30 calendar days. The expanded FMLA provides 12 weeks of leave. It's a supplement to the standard FMLA. So if you have an employee that has already taken 3 weeks of regular FMLA leave, they only have 9 additional weeks available under this expanded FMLA leave. The first 2 weeks of the expanded FMLA are unpaid. If an employee has not already used their paid sick leave can be used to receive compensation for those first 2 weeks. Weeks 3 through 12 of the expanded FMLA are paid. They're capped at $200 per day or $10,000 in the aggregate, or it is calculated as 2/3 of the employee's regular rate of pay. So if 2/3 of the employee's regular rate of pay is less than $200, they receive that per day. If it's more than $200, they receive $200 per day. Like with the standard FMLA, there's the requirement to return the employee to the same or equivalent position when the FMLA leave ends. And again, you can exclude healthcare providers and emergency responders under the eligibility for the expanded FMLA. Both of these provisions have a new poster that was released by the Department of Labor that you're required to post for your employees to inform them of their rights under this act. It is available on the DOL website. If you don't have it and you need a link for it, feel free to reach out to any one of us and we'll make sure that it gets to you. So now I'll turn it over to Duncan to discuss some things he's seen with the labor side.
Okay. Well, it's still good morning, so good morning.
Just one question. Will that notice, will that be on our COVID-19 special web page?
I don't believe it's posted there now. I can talk to Jane about posting it there, but I will send it out to all of the Halloran Sage attorneys participating in this. So if any clients ask for it, we all have it at our fingertips to provide it.
Thank you.
You're welcome.
I just wanted to take a couple of minutes to share with you all some of the observations that we have seen on the collective bargaining front since our new reality began. It seems that both towns and unions with contracts that are expiring on June 30th of this year seem to be willing to discuss one-year extensions of those contracts, notwithstanding the fact that the 5-person limit probably would not apply to towns and unions getting together to negotiate new collective bargaining agreements. People really don't seem to be interested or willing to get in the room with other folks to try to hash these things out. And so what we have seen so far is that both sides seem to be willing to agree upon some type of modest wage increase, sign off on a quick MOU, and come back a year from now and start the process again. And by way of example, we've just negotiated one-year MOUs with 2 town hall bargaining units in conjunction with AFSCME. We've done a highway department unit with the Teamsters, and we're in the process of doing another one-year extension for a highway department group with NAGE. So it seems like that virtually all of the unions are interested in exploring this process in order to gain some amount of certainty fairly quickly. And so far, the wage increases that we have seen have been in the range of 2 to 2.25% for that one-year extension. And the factors that seem to come into play in reaching those numbers are what have been the wage increases over the course of the contract that is about to expire. So if there have been, say, 2% increases in each of a 3-year deal, maybe you can get away with a 2% increase for one more year, and then negotiate, next March. The other factor that seems to come into play is if you have other bargaining units in town, what are those units getting come July 1 of 2020? So, for example, if another bargaining unit, was getting 2.25%, this unit, which is about to expire, says, hey, look, give us the same thing that you're giving to the other folks, and we can call it a day. And so it seems to be working so far. I really haven't seen any resistance by any labor unions to or aspire to get to the bargaining table to hash things out. The other options are, okay, if you're not going to sign a one-year extension, you can try to ride this out, which is probably going to be, at best case, early to mid-June, before we probably have this in the rearview mirror. And so then you're looking at, something less than 30 days before the contract expires to negotiate a new deal. Of course, you can, sign a waiver of the time limitations and continue negotiating into the new fiscal year. The problem that you then run into is budgetary. What have you planned for? And if you wind up going to binding arbitration somewhere down the road, how is that going to impact what you have budgeted for the 2021 fiscal year? The other option, I guess, is to try to do something like this and have the negotiations take place via Zoom or one of the other video chat applications. The problem with doing that, as I see it, is logistical. You can certainly have the initial meeting or negotiation session in something like this, but then how do you break out if you want to caucus? Do you leave this on? Do you open up a new video chat so that certain people can leave this one, go to a second one, have their caucus, and then come back to this? Or do you leave this and have a telephone conference call to discuss those matters and then come back into this? So, while I guess it can be done, there are certain logistical issues that you have to navigate. And so, given all that, I think that's why the opportunity to do a quick, simple 1-year extension of the contracts that are about to expire seems to be tantalizing to both the municipal employers and to the respective bargaining units. So that's what we've seen on that front over the last several weeks. And I think I'm the last speaker, so we can certainly open up the floor to questions on any of the topics that we have raised, or anything else that you folks want to ask us about.
Thanks, Duncan, and thanks, Jen. What we're going to try to do, again, having not done this with this big of a group, if anybody can send an email to me, as you see on my laptop, you're welcome to send an email, slater@halloransage.com, and I can read the questions out. But I think we could probably have an orderly effort of trying to just simply ask the question. If it turns out, as I said earlier, two of you are speaking at the same time, if just one of you could defer, and everyone will have an opportunity to ask any questions.
Yeah.
I'll try to moderate and direct it to the person who I'm guessing might be best to answer it, and they can kick it around if I'm wrong. So with that, any folks have any questions? And you can be detailed about specific. This isn't like going to a 100-person session where somebody tries to take over the conference with one particular detailed question about their town. Our intent here is for you to be able to get into detailed questions if you have them.
And you may have to unmute yourself.
Unmute. Yeah. Go ahead, Elaine.
Hi, everyone. I guess not a question, but I'm following along some of the executive orders, and I was scribbling down certain numbers. I've reviewed some in relative detail, but I wouldn't mind a summary from Halloran Sage of, these are municipal meeting related, these are budget related, these are HR related.
Yeah. And Elaine, I think if you go onto our website, and take a look at some of the client alerts that we've done. We've put them in categories. And so that may be helpful to you. And obviously, if you have any follow-up questions, just reach out to any one of us and we'll be happy to try to answer any particular questions that you have.
And just as a quick one, the ones I think you're going to see 7B and 7C and
7I and 7S, right?
Anyone else? What do you got? Erica.
First, I want to thank you all for all of your efforts and help during this time. It certainly helps flush out all of the many questions that we've had. I want to make sure I understood right. If we're having a regular meeting, so say a Board of Selectmen meeting and a Board of Finance meeting, not a public hearing, do we need to have that similar language on our agenda where folks can post public comment prior to the meeting? Or if we have a present to speak available, is that sufficient?
In your regular meetings, and other folks can jump in if they disagree, in your regular meetings, the public doesn't have an opportunity, doesn't have a right to participate. And so unless the board, for whatever reason, wants to give the public an opportunity, you'd need to do those accommodations. But otherwise, what the executive order would require is just to enable people to watch it in real time, just like they might in the audience if your normal agenda is such that you're not going to be giving the public an opportunity to speak on a particular agenda item.
Okay, great. Thank you.
Janine, go ahead.
Hi, forgive me if this was answered. I had to leave for just a few minutes, but are the state statutes for quorums for, say, land use commissions still in place?
Yes, quorum requirements haven't been waived.
Okay, thank you.
Nor have, for example, ZBA still needs four affirmative votes to grant a variance. That hasn't been waived.
So all the substantive
What are the
requirements.
ramifications if a commission isn't able to fulfill the quorum recommendations?
I think it would be the same as it is now. You just need to have a meeting within the time frame to act.
But you can do it entirely telephonically or entirely, so if you had folks that for whatever reason didn't have access to computers and it was a matter where you were facing a potential automatic approval on a site plan or a subdivision, hopefully you can just line up a quorum of people to get on the phone and, worst case, deny it because the application's not sufficient or whatever other reason you might do it, but just to get some kind of a decision on the record. But if you don't, you are at risk because the orders don't give you any accommodations for requirements to act on time, subject to getting all the extensions that Mike was talking about.
Thanks very much.
Although one additional thought on that, Janine, is you do have that 90 days. If to
Right.
gear up, you've got that cushion, even for automatic approvals.
Okay, thank you.
Pam,
Yes,
You're
I
welcome.
was wondering, Mike said that we needed to add some things into the town, permanent town records, and I wanted to know what exactly is it that's required now that wasn't before?
Okay, let's see, am I muted? No, okay. Basically, any notice that you would normally have to have placed in the town hall or in the agency's permanent written records. I think what this is intending to say is that if you normally would have had to file some sort of a written document in the town clerk's office or in the agency's office or somewhere in the town hall, at some point after the town hall is opened and people are able to get into the town hall as they normally would, those documents should be filed. Those same documents should be filed. I think the idea is that the electronic substitution is all well and good, but we do want to have some sort of a permanent record at such time as the COVID-19 situation goes away enough for people to be able to get into the town hall and see those written records. They're still necessary for historical purposes. We'll still need to see some of those documents in 2 and 3 years when all of the electronic things have gone away. And so the idea is just once you're able to get back into the town hall, any kind of a document, any kind of a notice or an agenda or whatever that you might have filed, it's a good idea to just file it at that point. Have it prepared and filed in the town hall. You're given a reasonable opportunity to do that. There's obviously going to be a backlog on that, so nobody is going to be expecting these things to be filed instantaneously, but the idea is we still want that paper historical record at such time as we can actually get back into the town hall.
And I'd add one thing to that, and it touches also on something that Mark, I think, had raised before about taking screenshots. Probably be a good idea, taking a picture with your phone or a screenshot, but I'd also encourage you to talk to your IT staff, because things have progressed so much that sometimes there is backups that would be available that would be able to capture what was on your web page at any given day. And if not, they might be able to make accommodations to make sure that things are getting saved every day during this odd period of time. So there might be another piece of evidence that notice was in fact posted on your web page. So I encourage you to talk to IT to see whether that's can be accomplished. Also, we're seeing people raising their hands, which is wonderful on the folks that are on for video, but please don't hesitate for folks that are just on audio from the phone to just speak up, and then we'll defer to you if you have a question. Anything else from anybody, folks?
Just one thing on that, following up on that same question. I'm looking for comments from Mike particularly, but I'm assuming that let's say you get a special permit approval, and it's not effective until filed in the town clerk's office, says the statutes. I'm assuming that you could put it on the website. That would be the effective date of your special permit. You could then proceed to get financing or whatever, because it's now effective. When the clerk's office reopens, you confirm that by a paper filing. And I guess the only thing you'd have to be careful of is that when you do that paper filing, you're going to want to put somewhere on it, this was actually effective on the date I put it on the website. Do I have that scenario right?
Yeah, I think that's a great point, Mark. Yeah, certainly the Order 7I does allow any notice that would normally have to be filed in the office of the municipal clerk to be posted electronically on the municipality's website. I think probably what you would want to do on the notice itself is say this permit is effective as of, or the date of filing of this document is X, so that when the paper file does actually go into the town clerk's records, that date is stated. That's a very good point. Very good point.
Thank you, folks. Any other questions before we break off?
I have a question. It's Carl Fortuna from Old Saybrook. How are you?
Hey, Carl. Good. How are you?
Good. Not on your agenda, but Executive Order 7S with regard to Airbnbs. Have you given any thought to that? And like, I have someone email me this morning about an Airbnb here in Old Saybrook that is currently rented out to, of course, those evil New Yorkers, and they looked online, and the Airbnb is indeed booked
17,
like next week or the week after for an additional Airbnb stay. So does that apply to the people who are currently in there, number one? And how do you enforce it? Any ideas?
Anybody? I got to confess that's, I think it's 7T, and that's a new one that I haven't studied. Carl, why don't we take a look at that, and then we can reach out to you?
That's fine. Yeah, that's
Unless
great.
somebody else, Mark, do you have any comments on that one?
I do know that I'm pretty sure the first selectman of New Milford, under local state of emergency provisions, has ordered all B&Bs to cease operation. And I know a couple of our first selectman clients are looking at that have already declared local states of emergency, are looking at just prohibiting all B&Bs for precisely those kinds of reasons. How you enforce it, Carl, that's obviously much more difficult.
Actually, that's good insight, actually, right there.
Well, I think 7T that was issued last night probably overrules any local authority to do anything inconsistent. I'll admit that last night I was spending more time trying to figure out how to fix 7S than I was looking at 7T. But
Yeah, and glancing at it, I mean, certainly Airbnbs are covered, other than the exceptions that are, healthcare workers, things like that, that are outlined in that order. So there is an intention to prohibit at least a lot of that use.
Okay,
I mean,
thank you.
and enforcement of these orders, I mean, it's through emergency services and public protection or whatever, kind of legislative or gubernatorial clout you might have by making phone calls.
Okay, thank you.
The other thing, I think from the CAMA discussions on the CAMA website have been that since this is all uncharted territory, we can act first and figure it out later. Carl, in your case, you have a police department, and if you've ordered B&Bs to be shut down, or if 7T does that, I would not hesitate to use police, because it is a state of emergency, and I don't think anybody who brings a civil rights action because they lost their vacation interval is going to get very far.
Thank you.
And that touches on, we have some expectation, who knows, because things don't move so quickly under right up the road from where Rich and I are sitting. But there is an expectation that after the dust settles and we're past this crisis, that there'll likely be a validating act that the legislature, to the extent that the governor's overextended executive powers, that it will validate the actions that it's done during this period of crisis. And to Mark's point, we think that courts will likely be accommodating, but you just never know with somebody in a black robe accommodating to this crisis, and if there were appeals brought and actions brought. Anything else, especially from folks who might be on a telephone line that can't raise hands?
I have a question on the tax deferment and low interest. Can that be done as first of all, does it have to apply to all classes of property? Can the town do just real estate, for example?
The way it's written, it applies to all taxes, including motor vehicles, personal property, and sewer and water charges.
Another question is, can it be done by default? In other words, there's a qualification for landlords. Can they just say, we're deferring the taxes, and at sometime in that 90-day period, the landlord will have to show that they qualify?
Frankly, I think that's probably what's going to happen is, just because landlords may not necessarily in advance be able to, demonstrate today that they've provided the same level of forbearance to their tenants that they found out about 36 hours ago in an executive order, it may very well be kind of after the fact cleanup verification.
Thank you.
Yeah, Mike had something. Mike D'Amato.
Yeah, Mike, go ahead.
Would you suggest, or how would you suggest towns deal with documents submitted as part of a Board of Assessment appeals application? Should those go up on the website?
If they're documents that are going to be discussed at a public meeting, I mean, frankly, I think some of the documents that you submit to assessment appeals, like, the financial records and your internal tenant information is not subject to freedom of information in the first place. I certainly wouldn't post that on the internet. I think somewhere toward the back of 7S, it does talk about dealing with finance. 7I and 7S do have kind of throw-in provisions about boards of assessment appeals, but I'd say that, anything that wouldn't be a public document that needs to be filed with the BAA in order to qualify for an exemption or to, demonstrate that you are eligible, that you've been over-assessed. If those are things that wouldn't ordinarily be public records, they should be distributed to the members so that they can look at it, but I wouldn't post them on the website.
Anything else, folks? Not trying to rush anybody, but just trying to make sure everyone's had an opportunity. And if not, we'll.
You know where to find us.
Yeah, exactly. Any of these things that come up after we have this discussion, or as these orders continue to come up, we're going to try to continue to send e-blasts out as they come in to keep you up to speed. But you know where to find us. We're up and operational with any questions that you have going forward.
And just Ken, on that point, the people like Rach that are working on these orders. They're getting questions and comments and clarifications. You're going to see these evolve and change and grow with experience and to answer some of these kinds of questions. I saw something on the site this morning. There was a question about the tax deferment. Does it apply universally? There is some discussion about allowing some discretion there. So I think you'll see these orders change as we learn more.
Agreed. All right, folks. Well, thanks so much for participating. The speakers for joining in today and for working us. We enjoy working with you as a team and wanted to give you this opportunity as our clients. And we appreciate the business and we look forward to continuing to serve you. Have a great day, folks, and be well.
Take care.
Take care. Bye-bye.